Now, Pavarotti was a good friend.
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. As a disclaimer, this channel is for entertainment purposes. These are my opinions. I'm not here to slander anyone, so why don't we just get into it? In today's episode, I want to dive in really deep to the alibi. I mentioned in my video yesterday, which is repost today, I got a lot of questions in my 5-part series, and one of them was discussing how Ann Taylor said that Bryan Kohberger was not in Moscow at all. I've continued to go through those court hearings, and I've still, that statement I don't believe has ever been actually said. I believe that has been taken from some of the information in the alibis, and it's easy to take it that way because of the way the alibis are. They're carefully worded. But what I've done, because it's this alibi thing is it's very strange, especially when you read the Idaho criminal rules as it relates to the alibi and all the requirements in Idaho. So what I've done is I've taken all of the back and forth since this case started as it relates to the alibi, and I've pulled all those docs. I've created a timeline, and I think once you watch this, you're going to be very familiar with why I keep bringing up this alibi statement and why that nobody's talking about it. And it's kind of, it's shocking to me, but you're also going to have a good understanding of my 5-part series, because again, I put a lot of information in there to try to back up why I feel everything in my 5-part series happened that way. But there's no way I could put everything in there. As we go through this video, if you pay close attention to that 5-part series and you pay close attention to what I'm going to be discussing today, you're going to start to see why I feel like things happened the way they did in my 5-part series. So, with all that being said, let's get started. Okay, folks, so one of the things that I think we'll take away from this is the DoorDash driver has to be one of Kohberger's alibis. I mean, there's no way around it. But let's get into it. Now, my pointer never wants to work right for me. Okay, so on May 23rd, 2023, that is the first time that the state has requested the alibi from the defense. And that's going to be important as I go through this, and you'll see why. And you'll see this is the state's discovery request from the defense, for the defense's discovery that has to be provided to the state. And at the bottom of it right here, you see that in all capital letters, it says, "Further, the state hereby demands of the defendant notice of defense of alibi pursuant to Idaho Code 19519 and Idaho Criminal Rule 12.1. Now, Idaho Criminal Rule 12.1 is very general. It's just on requirements of the defense and the prosecution to provide each other with the discovery that they have to provide each other with. It doesn't go into a lot of detail. But Idaho Code 19519 goes into a lot of detail, and we're going to discuss that. Now, this is dated, you can see here, the 23rd of May, 2023, and it is very important, this particular date on this particular document. And let me show you why when we go to Idaho Code 519, because that relates to the alibi. Okay, so you can see here, Title 19, Criminal Procedure, and 19519, Notice of Defense of Alibi. Now, at any time after arraignment before a magistrate upon a complaint and upon written demand of the prosecuting attorney. Okay, so I've got that underlined, and that's important because when it says upon written demand of the prosecuting attorney, a timeline starts. And that's why that 5/23/23 date is very important. The defendant shall serve within 10 days or at such different time as the court may direct, which means it can be a different time if it's ordered by the judge, John Judge, to alleviate that 10-day timeline. Once that prosecutor filed that motion, the only way it can exceed that 10-day timeline is if the judge actually orders on it that they can have more time. But upon the prosecuting attorney a written notice of his intention to offer a defense of alibi, such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. So the reason that I've pointed out and I've underlined like specific places, time of the alleged offense, is because you're going to notice as we start going through the other alibi-related documents, you'll hear both the defense and the prosecution state, mainly the prosecution, are going to state several times about specific places and specific times as it relates to the atrocity itself. So that's very important. And what I've found by going through this is, it's kind of strange in the fact that the prosecution and all of their requests and everything they've done around the alibi, they follow this Idaho criminal procedure to a T. So truly they have done what they're supposed to do, and it's the defense that's scooting around, the things that they're supposed to do as it relates to this alibi. But I know exactly why they're doing it, and I'm going to show you that as we go through it. Okay, so within 10 days after receipt of the defendant's notice of alibi, so again, 10 days after this receipt, 5/23/23, but in no event less than 10 days before trial, unless the court otherwise directs, the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom the prosecution intends to rely to establish the defendant's presence at the scene of the alleged offenses, and any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses. So according to the Idaho procedures, they ask for the discovery, which is where were you at during the time of the atrocity specifically, and who are you going to be providing as a witness to corroborate your alibi. They do that on 5/23, a timetable starts. Now, after the defense provides that, then, according to the rule of law, then the prosecutor gives them a copy of the list of witnesses that they're going to use to place the defendant at the scene. So, as much as the defense would like to have that list of witnesses before the prosecution gets their alibi, the Idaho law says the defense has to do it first. Now, that's going to be very important as we move forward. So I wanted you to really understand the Idaho criminal rules of procedure as it relates to this. Now, if prior to or during trial, a party learns of an additional witness whose identity, if known, should have been included in the information furnished under subsection 1 or subsection 2 of this section, the party shall promptly notify the other party or his attorney of the existence and identity of such additional witnesses. Now, this would only come into play after the first procedure is complete. And remember, the first procedure is the state requests the alibi statement. You got 10 days. The defense gives them their alibi statement and their witnesses. And then within 10 days, the prosecution provides the defense with the witnesses. So After that process is over, then the additional witnesses would come into play. Not before, though. And we are nowhere. This should have happened within 20 days of this being filed originally at 5/23/23. All this should have happened. But we still have not completed this process right here that should have happened back in May of last year. Now you can see at the bottom down here it says, upon the failure of either party to comply with the requirements of this section, the court may exclude the testimony of any undisclosed witness offered by such party as to the defendant's absence from or presence at the scene of the alleged offense. This section shall not limit the right of the defendant to testify on his own behalf. Now, I underline that because you'll notice when we get into the replies from the prosecution on the alibi going forward, he always ends it with, he's asking for an order for the defense not to be able to provide any additional witnesses, and Kohberger should have to testify on his own behalf to where he was. And I always thought that was really strong language, but after reading the Idaho criminal rules, I mean, all he's doing is putting exactly what the criminal rules state into his argument. So Thompson's actually following this, to the letter. And then lastly, it says, for good cause shown, the court may grant an exception to any of the requirements of subsections 1 through 4 of this section, and that has to be by order of the judge. And now we got Hippler, but back then it was John Judge. So the only way all of this doesn't comply is if there is an order by the judge. And I'm gonna show you throughout this entire process, John Judge never ever orders anything related to the alibi. So this is a screwed up thing, folks. But let's continue. Okay, the next thing that happens is on June 9th, 2023, the defense files motion for extension. Now remember, they were supposed to reply with the alibi within 10 days. So that means on 6/3, this thing's past due and sanctions could have been put on the defense. But somehow they waited another 6 or 7 days and then they file a motion for extension. And here's what they filed. You can see it says Mr. Kohberger has filed a contemporaneous motion for an exception, or in the alternative, an extension of time for notice of alibi. And I put in the notes here that is 6 days past the deadline when they filed this. So that you were late on this, Ann Taylor. And this was dated the 9th day of June, 2023. Now, the next thing as it relates to the alibi happened 4 days later, 6/13/23. Prosecution stipulates extension. No judge ruling needed. So when they stipulate to each other, that means that the prosecution and the defense is in agreement on something, and they're making that agreement outside the judge's approval. So since the judge didn't order for the extension, the prosecution stipulated it. It's essentially the same thing as the judge ordering for an extension. And here is that document. And it says, balancing the above, the state has no objection to a reasonable extension time for the defense to comply with its obligations under Idaho Code 19519, with the understanding and expectation that the state will likewise have a reasonable period of time to respond to any proffered notice of alibi, and with additional understanding that any defense compliance with Idaho Code 19519 needs to occur before July 24th, 2023. So the defense, even though they were late on filing their extension, the prosecution stipulated. They said, no problem, we'll give you more time. You have till July the 24th, 2023. So really, I mean, they were kind of being cool about it at this point, because they could have really hampered down on this. But the prosecution gave the defense a lot of leeway. Then on 7/24/23, remember that said he gave them till 7/23, so she's a day late on this one as well. Not trying to be hard on Ann Taylor, but this is the facts. Facts are facts. And but on July 24th, 2023, the defense submits a partial alibi. And here it is. And it says, "Come now, Bryan C. Kohberger, by and through his attorney of record, Ann C. Taylor, public defender, and hereby files notice in response to the demand for alibi in compliance with Idaho Code 19519. Mr. Kohberger notes that the Idaho Code preserves his constitutional right to silence as well as to testify on his own behalf. Mr. Kohberger stands firm on his constitutional right as well as the statutory recognition of that right. Noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. A defendant's denial of the charges against him does not constitute an alibi, but as soon as he offers evidence that he was at some place other than where the crime of which he is charged was committed, he is raising the alibi defense. Mr. Kohberger's defense team continues investigating and preparing his case. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state as well as calling expert witnesses." So, again, this is a day late, and when we read Idaho Code 19519, it stated in there clearly that to bring up an alibi, he had to state where he was at a specific date and a specific time and name his witnesses. So this that she filed on this date, even though that they were given a lot more time, does not comply with Idaho Code 19519. So she filed this, but I mean, if the judge took everything that I just showed you just on face value, I mean, he could have actually ruled right here that Bryan Kohberger wouldn't be allowed to use the alibi defense, call any witnesses on his behalf, and he would have to testify on his own behalf if he wanted to use it. But that didn't happen. And the reason that the defense had to do this at this point is because you can see it says Mr. Kohberger's defense team continues investigating and preparing his case. And they did not have the ability to state that they could corroborate him being somewhere else because Cy Ray even if he was on board, he hadn't completed anything at this point. It is my thought that Kohberger, since he did have a good understanding of cloud-based forensics, I believe Kohberger knew that there was some way that Cy Ray was going to be able to corroborate that he was at Wawaway Park at this point. But until Cy Ray was actually able to do that, they're not going to bring it up in this other than possibly. And the other point is, it says evidence corroborating Mr. Kohberger being at a location other than the King Road address. When it says that, that's not necessarily saying he's not in Moscow. That's just saying he's not inside that King Road address when this happens. So the other problem that they had is they're expecting to corroborate things based on cross-examination of witnesses produced by the state. As I'm going to show you here in just a minute, they do not know what that witness that's going to be produced by the state has actually testified to at that point. So even though Kohberger knows that that person should be able to corroborate it, without them knowing what their statements are at that point, they cannot openly express that. So I believe that's why Ann Taylor, instead of going with a full defense disclosure, did this instead and was hoping for a good outcome on it. Now the next thing that happens is 3 days later, Bill Thompson's all over it. Prosecution files motion to demand alibi or exclude alibi. Now I cannot blame them at this point because based on the Idaho Code, they should have provided the alibi at this point. And they gave them an extension, they let them be late, and then they didn't get what they were told they were going to get. So This is the prosecution clamping down. Okay, and here it is. Motion to compel notice of defense of alibi or alternatively to bar certain evidence. And you see, comes now the state of Idaho by and through the Latah County prosecuting attorney, and they respectfully moved the court for an order. So they're asking John Judge to order. They want to compel the defense to comply in full with Idaho Code 19519 that we looked at earlier. And what do they specifically want? Just what Idaho Code 519 says they should have. A specific place or places that the defendant claims to have been at the time, and the names and addresses of all the witnesses the defense used to establish the alibi. So they're just following the law on this straight up to the T. Now you can see it says, as the court file reflects, the state filed its request for discovery disclosure, alibi demand on May 23, 2023, and served the defense on that same day. The parties subsequently stipulated to extend the statutory time for the defendant to provide notice of alibi and comply with Idaho Code. And we looked at everything. That's exactly what happened. And then on July 24th, the defendant filed a notice of defendant's response to alibi demand. This document does not comply with the requirements of Idaho Code, and no, it doesn't. In that, it does not specify a place or places of which the defendant claims to have been at the times of the offense, nor does it provide the names of the witnesses. The state recognized that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. However, as noted in these cases cited, the defendant's right to call witnesses is his or her defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. And that's all fair. I mean, that's just like the code reads. And as the Juarez court also observed, if requested by the state during discovery, a defendant intending to offer alibi must file notice where the defendant claims to have been at the time of the alleged offense, names and addresses of witnesses who the defense will call to testify as evidence, and notice of defendant's response to state's alibi demand. The defendant has failed to comply in any fashion with the requirements of the statute, court rule, and applicable law. And they're exactly right. They didn't do anything that the Idaho rule requires them to do. And then it says it's important to note that the scheduled October 2nd, 2023 jury trial is barely more than the 2 months away. Now, here is the issue with everything in this, folks, is everybody, including myself, is really hammered that BK should have taken the early October 2nd speedy trial date and not pushed it off. But here's why he couldn't, especially if you watched my 5-part series, because he had to agree to extend the trial date to get Cy-Ray's data proving the trip to Wawawe Park. If he doesn't have that data proving that he went to Wawawe first, because once you drive to Wawawe, you cannot get to the King Road neighborhood before 4:04. It's impossible. The time is impossible. You can't do it unless you get in an airplane. So by having Cy-Ray to corroborate he went to Wawawe Park, that proves that's not his car making those first 3 passes around the house. And that was the prosecution's number 1 piece of evidence against Kohberger. That he had driven around that house so many times before he parked, he had to be the assailant. Now, once you eliminate those first 3 passes, then him meeting that DoorDash driver there at the house, like we discussed, or close to the house, would be a lot easier for a jury to believe that he didn't commit the atrocity if he's not in that other car that circled the house 3 times. At this point, though, they don't have the discovery for all the information that Cy-Ray would have needed to be able to corroborate the Wawawe trip. So going to that speedy trial, they would have had a good chance of proving or making it look like that was his car doing all of that. And it wouldn't have gone good for him. So he had no choice but to extend out this case farther than he had to because of not being able to prove that he went to Wawaway Park. That's a key in this thing. Now, to provide prompt notice so the state can fulfill its obligations under Idaho Code to investigate and respond to the notice of alibi. Any further delays will substantially prejudice the state's rights. Similar to the situation in Juarez, the state has no idea how the defendant's notice regarding alibi constitutes an alibi, as observed above, and it doesn't because they didn't give any of the information in there that would constitute an alibi. So the state's unable to comply with ICR 12.1 and Idaho Code, and when he says the state's unable to comply, that means his 10-day timetable starting so that he provides the defense with his list of witnesses. He can't do that because the defense has not met their burden of the information they need for their alibi. And then I like his last statement here. He said, we don't know how this is an alibi at all. And I agree with you on that one, Bill, because it's not. But then it says the state also notes the Supreme Court observed in Taylor versus Illinois the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. And it says the adversary system of trial is hardly an end in itself. It's not yet a poker game which players enjoy an absolute right to always conceal their cards until played. So this is where Thompson starts to realize that the defense knows something that he doesn't, but he's not going to come to a complete understanding of that for just a little bit, and I'll show you that. So again, it says, based on the above, the state praised the court for an order compelling the defendant to comply in full with the Idaho Code. So he's begging the judge to actually follow Idaho Code, and then what it talks about here is all the stuff in Idaho Code again. Okay, then it says, alternatively, the state prays for an order for this court pursuant to Idaho Code prohibiting the defendant from presenting any evidence, whether by direct or cross-examination in support of any claimed alibi other than from the defendant himself. So what they're saying is either comply with Idaho Code or you cannot use the alibi whatsoever, and you have to get on the stand yourself and defend yourself. And all of this complies with the Idaho Code, just exactly how it's written. So I can't get mad at Bill Thompson for this. He's basically copying and pasting in this motion right out of Idaho Code. So based on that, the judge should have ruled at this point. Either give the defense more time or ruled that they can't present an alibi. I mean, that's just the facts of life right there. But instead of the judge ruling, the defense on August the 2nd, 2024, which was about 5 or 6 days later, they file an objection to the motion that the prosecution filed. So let's take a look at their objection. Okay, so you can see here on 8-2, this is the defense. This is their objection to the state's motion. And it says, come now, Bryan Kohberger, through his attorney of record and Taylor, hereby objects to state's motion to compel the motive of defense of alibi or alternatively bar certain evidence. And then they cite Idaho Code 19519 requires an alibi disclosure of a specific location and witnesses to testify. By statutory definition, Mr. Kohberger may remain silent yet testify that he was not at 1122 King Road, November 13th, 2022. And again, its wording is very, very critical. By him not being at 1122 King Road, that means inside the residence. That doesn't mean near the residence. However, in an abundance of caution and recognizing the court has authority to exclude witnesses, Mr. Kohberger has indicated he anticipates corroborating witnesses. So she's letting him know that he's going to have them, but not at this point, so they can't complete the alibi. And you can see she cites this case, and it says, when determining whether to exclude evidence due to late disclosure or non-disclosure, the trial court must weigh the prejudice to the state against the defendant's right to a fair trial. It is error for a trial court to exclude a witness based solely on the late disclosure without analyzing whether the state would suffer prejudice from the late disclosure. And the reason she's citing this is because the witness that they're going to be disclosing is actually the state's own witnesses that they're going to be presenting. So by them being late with the disclosure, it's not going to prejudice the prosecution. They're not going to suffer from the prejudice because their statements are going to come from the witness the prosecution is going to be presenting. So there's no way to hurt the prosecution is what she's citing. And then down here you'll see the first time she starts discussing what Kohberger did that night. It says, Mr. Kohberger has long had a habit of going for drives alone. And it's very important how she words this stuff, folks. And you're going to see because she morphs it every time we get a new statement just a little bit. So the language is very important the way she does it so that she can slightly alter it going forward and it still be completely legal. So Mr. Kohberger has long had a habit of going for drives alone. Statement in itself. Often he would go for drives at night. Statement in itself. Neither one of these have anything to do with where Kohberger was the night of the atrocity. He did so late on November 12th and into November 13th, 2022. See, he did so. She didn't make any statement right here about Kohberger going for a long drive or driving at night. She made separate sentences on purpose, and she said he did so. So that means absolutely nothing, and that can be absolutely argued in court. Mr. Kohberger is not claiming to be at a specific location at a specific time. He's not claiming to be. Not that he won't tell you where he was, but he's not claiming to be. Very important language. And that's the end of that sentence. So when it says, at this time, you can't carry that one over. So it's not to be at a specific location at a specific time at this time. No, that's an end. So at this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between the late night November 12th and early morning November 13th, 2022. And again, neither Kopaka, Cy Ray, the DoorDash driver, none of them can testify to where he was at each moment of the hours, especially Kopaka because he's no longer with us. He was out driving during the late night and early morning hours of November 12th through 13th, 2022. That's it. Counsel for Mr. Kohberger is aware that case law broadens the definition of alibi with the statutory requirement of a specific location to more broadly include disclosure of information that tends to state the person claiming alibi was at a place other than the location of the offense. Mr. Kohberger has complied to the extent possible at this time. He can't state exactly where he was at this time because he still does not have Cy Ray to be able to corroborate it. You got to have a witness that can corroborate where you were at that time. And he certainly doesn't have Kopaka anymore, and he does not have the DoorDash driver being able to corroborate anything other than where he was at 4:06. Now, corroboration of Bryan Kohberger not being at 11:22 may be brought out through cross-examination of the state's witnesses. And they say may be brought out because, again, they don't know exactly what the state witnesses have testified to at this point. At this time, Mr. Kohberger cannot be more specific about the possible witnesses and exactly what they will say. The defense has been hampered by the state's own choices. The state chose a secret grand jury rather than the planned preliminary hearing. Had the state moved forward with the preliminary hearing, the defense would have had the opportunity to develop testimony through cross-examination and witness presentation. So, because they did the secret grand jury, all they've got is the transcripts from it of the prosecution asking the questions they wanted to ask, so they don't know exactly what the witnesses will testify to because of that. Instead, the defense is only received on July 27, 2023, and remember, it's only August the 2nd right now, excuse me, when she's filing this, so she's only had the copy of the testimony the state chose to elicit during the grand jury for 5 days at this point. The defense has had to obtain investigative materials from the state's investigative counterparts, the FBI, through an order compelling the state to provide such materials. The state made draft disclosures just 2 weeks ago. The sufficiency of these disclosures is currently being analyzed. And when they talk about the draft disclosures that they made 2 weeks ago, we already know what those are now, because 2 weeks ago was the oh, no, I'm sorry, I was getting confused there. Okay, so the state made draft disclosures 2 weeks ago, so they just got the draft of the cast data, and that's not enough time for Cy Ray to do his corroboration. But the main thing is they don't have the testimony of the state's witness, that's Kohberger's witness, because they just got the transcripts from the grand jury and the correct questions weren't asked to them. So they're not having a chance to even go and depose this witness at this point. And in fact, at this point, if you read the way this says, instead, the defense has only received a copy of the testimony the state chose to elicit. At this point, because Kohberger has not given his alibi, the state has not started their 10-day window to give the disclosure of their witnesses to the defense. So even looking at the testimony from the transcripts of the grand jury witness, I don't believe that they would even tell the defense who that witness was that was testifying at the grand jury at this point, because they don't have to due to Idaho code. So they may have the statements from the witness, but they don't even know for sure who the witnesses are, even though they probably do because Kohberger knows who his witness is. But anyway, corroboration of Kohberger not being at 1122 King may be brought out through expert witness presentation. That analysis is underway. That's Cy Ray. The defense has been diligently working to analyze relevant discovery materials and conduct its own investigation. Notably, the defense has had to obtain a court order to receive relevant discovery materials, and that's the cast data for Cy. That delay hampers the defense's investigation. And then they cite case law. The defense acknowledges the vast amount of discovery has been provided. Discovery is received on a nearly weekly basis. The defense reviews and acts on discovery as quick as possible, including making appropriate supplemental requests for discovery. The state's motion is an attempt to force the defense to open its work product files and let the state peek inside. The defense has stated all that can firmly be stated at this time. This is not trial by ambush from the defense. This is the defense requesting information as quickly and as quickly as possible, yet in some instances face the delay of requesting a court order to obtain the information. The state continually uses those opportunities to attempt to force a waiver of speedy trial. That is a decision left to Mr. Kohberger and Mr. Kohberger alone. So Mr. Kohberger has to make the speedy trial decision based on where they're at in the evidence that they can corroborate. But at this point, he cannot even get his trip to Wawaway Park corroborated. That's why he finally had to decide to waive the speedy trial, folks. But Mr. Kohberger was out driving alone. Yeah, Mr. Kohberger was out driving alone until he picked up Kopaka. And you've got to watch these statements like this because that one's going to morph in the next alibi statement. Corroborating evidence may come from cross-examination of state's witnesses. That's the DoorDash driver. Corroborating evidence may come from the presentation of defense experts. That's Cy. Mr. Kohberger is aware of and will comply with his continuing duty to disclose information. The court may exempt Mr. Kohberger from further inquiry. Mr. Kohberger requests such an exemption at this time. Continued inquiry at this juncture delves into his case investigation as well as his protected work product. In support of an exemption, Mr. Kohberger is prepared to provide further detail in an ex parte hearing with the court, which means a hearing just with the defense and the judge without the prosecution there. So the weird thing is there's no record of this ex parte hearing ever taking place. And even with all of this back and forth on this subject, the judge never rules on this. And this is where it starts to get strange why the judge hasn't ruled on it. Okay, so you'll see that on 8/2/24, the defense filed that motion. All that back and forth has happened. And I've been all through the court records. The judge never rules. And then this subject isn't brought up again until April 2024 in the hearing when finally the prosecution brings it up because they were frustrated about the change of venue surveys that were going out, and you could tell that they were getting a little upset, so they brought the alibi up and started hammering the defense for it again. But that's from August of 2023, and then it's not brought back up again until until April of 2024, even after all that back and forth, which is very strange. By the way, in this box down here, it says 8/2/24. That's supposed to be 23. I apologize. I didn't do that on purpose, I assure you. Next, April 2024. Even though it's argued in the hearing, the judge does not order, and the state files a second motion to compel the defense for their alibi. So in that hearing, the judge is like, what, huh? We still haven't solved the alibi issue? He still didn't make an order on it. Instead, the prosecution files another motion to compel. And here it is. And it says, any notice of defense of alibi must be filed no later than April 17, 2024, if defendant intends to offer a defense of alibi. Now remember, the last thing prosecution had filed said either order them to give us the alibi or exclude the alibi altogether. Now it's like they didn't even file that thing, and they're asking for it again in a nice way. If defendant intends to offer a defense of alibi, the notice must comply with the Idaho Code and shall state specific place or places in which the defense or defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to establish such alibi. So he just goes back to the same old regular language like they started with in the beginning, and it doesn't make any sense at this point. I mean, they've already fought back and forth over and over, and then it just kind of went away. I mean, what kind of court case is this? Then, on April 17, 2024, just like the prosecution filed that motion to compel, the defense submits the second partial alibi. And that's the latest alibi statement that we've received. And we'll take a look at it. So, once again, we keep thinking this thing is an alibi statement, but the defense has never provided an actual alibi statement. This, again, is just a notice of defendant's supplemental response to the state's alibi demand. So this is just a response. Comes now, Bryan C. Kohberger, buying through his attorney, Ann Taylor, files a supplemental response to the state's demand for the alibi. And in compliance with Code Idaho 19519. No, not really. Mr. Kohberger moved to Pullman, Washington in June of 2022. As an avid runner and hiker, he explored many areas of the Palouse. Of note, he explored Wawaway Park in July of 2022, and this became a favorite location. After the school year began, Mr. Kohberger was busy with classes and work at Washington State University. His running and hiking decreased, but did not stop. Instead, his nighttime drives increased. This is supported by data from Mr. Kohberger's phone, showing him in the countryside late at night or early in the morning on several occasions. And again, folks, this was one of the things I didn't put in my Q&A yesterday, but when I was talking about the substances, I mean, we got right here Kohberger late at night or early in the morning on several occasions. So it's something that he did often. He worked all day. So to be out driving and running around throughout, the park late at night, all night, I mean, he's on substances, folks. The phone data includes numerous photographs taken on several different late evenings and early mornings, including in November, depicting the night sky. Now, the parts that I've highlighted here are really the only parts in all of this where they're stating what Kohberger was doing that night. And it says Mr. Kohberger was out driving in the early morning hours of November 13th, 2022. Now, you'll notice it doesn't say anything about November 12th like the other one did. Okay, so now it's kind of zeroing in just a little bit more because they have a little bit more they can corroborate. So he was out driving in the early morning hours of November 13th, 2022. And as he often did, or hike and run, see moon and stars. That has nothing to do with what they're talking about. He drove throughout the area south of Pullman, Washington, west of Moscow, Idaho, including Wawaway Park. This is the only statement in this entire alibi where it talks about what Kohberger was doing that night. And in this statement, you're going to notice it doesn't say he was out driving alone. It just says he drove throughout the area south of Pullman, Washington, west of Moscow, including Wawaway Park. No statement of alone. And this also eliminates BK's car as the one that makes the first three passes, because you can't go to Wawaway Park after 4:20 and get back to his apartment in the time that they got him on camera coming back. So the only way he could have gone to Wawaway Park is before the atrocity, and based on all of the timelines that I've shown you, he couldn't go to Wawaway and get to the King Road neighborhood before 4:04 a.m. So those first three passes of that car on camera is not Bryan Kohberger's. And then you can see it talks about offering testimony of Cy Ray to show that Bryan Kohberger's mobile device was south of Pullman, Washington, west of Moscow on November 13th, that Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours, and that could not be his vehicle captured on video near Ford's cannabis shop. So never once do they say that he did not travel east, period. They're just saying he didn't travel east initially. He went to Wawaway Park initially, which eliminates that first car's passes. So now you're starting to see what really happened. Additional information as to Mr. Kohberger's whereabouts as the early morning hours progressed will be provided once the state provides discovery requested. And that's including additional analysis by Cy Ray, because Cy Ray wants the drive test data of the actual King Road address. And there's a reason why he wants it of the actual King Road address, I assure you. And as we look at this, though, they're dropping hints now. The prosecution should be able to start picking up on what the defense is dropping, but they really don't. So, okay, so April 17th, 2024, defense submits second partial alibi statement. That's what we just read. On that exact same date, 4/17/24, TF is sentenced for probation violations. And here it is, 4/17/2024. He's sentenced after all of those arrests and charges. He finally gets sentenced on a simple probation violation on 4/17/2024. He's sentenced to 2 to 3 years in the Department of Corrections but he's credited for 407 days time served as of April 17th. I don't know how he didn't serve any of those days. And that would put him out of the IDOC just in time for trial. Then we have on April 26th, the state files response to the partial alibi. And you see here on April 26, 2024, response to defendant's supplemental response to the state's alibi. So comes now the state of Idaho, yada, 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 and they're responding to the alibi demand that was filed on April 17th. And he goes through a little bit of a history here, and he's right about this. At the outset, the state incorporates by reference, as it's fully set forth at this point, those portions of the state's July 27, 2023 motion to compel notice of defense's alibi or alternatively to bar certain evidence to the extent that it relates to the adequacy and timeliness of the defense alibi notice. So that's how we know the judge never did anything on this, because on April 17th or April 26th in his response to what the defense responded to on the 17th, he's referring to the last motion to compel on July 27th, or bar evidence. It was never, ever even talked about. The state respectfully submits the defendant's supplemental alibi responses continue to lack specificity required by Idaho Code, which provides that the defense shall be at a specific place or places, and he just goes through basically and cites Idaho Code once again. The defendant's April 17th submission minimally adds to the alibi notice that they dated July 24th. And defendant states he was driving around during the early morning hours of November 13th and drove throughout the area south of Pullman, Washington, west of Moscow, including Wawaway Park. With the exception of the reference to Wawaway Park, which is new, the defendant's offering nothing new to his initial alibi. He's simply driving around during the early morning hours. And he's actually right about that. As the state noted during the August 2023 hearing, the state's aware the defendant was driving around rural areas of Whitman County, Washington, and Latah County, Idaho during the early morning hours. In fact, the defendant's travels during that time are described in the original probable cause affidavit supporting the criminal complaint in this case. See what's happened here, folks? Thompson, he didn't think this through at this point when he's filing this. Because when he's talking about him driving in the rural area of Whitman County, he's thinking of after the atrocity. He's not thinking it through that if he went to Wawaway Park before the atrocity, and Cy Ray can corroborate that his Hyundai Elantra scenario goes out the window. As to the defendant's reference to the potential testimony about the defendant's cell phone on the morning of November 13th, this information does not rise to the level of an alibi at the time of the unalivings because the defendant's cell phone stopped reporting to the cellular network before then. And we've talked about that a lot, how there's no proof relevant to the specific location at the time of the homicides, 4 to 4:30, because there's no cell data, is what he's trying to say. He's not thinking it through. It is the state's position the defendant's continued failure to adequately comply with Idaho Code does not trigger a response under Idaho Code. If the court deems defendant's supplemental response to be in compliance, then the state requests additional time to prepare a list of witnesses to establish defendant's presence at the scene of the homicides. As to witnesses to rebut the claim of alibi, the defendant's failure to adequately comply with Idaho Code means the state does not know what specific assertions it needs to rebut. So at this point, he still can't provide that list of witnesses because he doesn't know what the defense is up to. He doesn't know what specific assertions he needs to rebut. And until he gets exactly what the defense is going to say that Kohberger was at the exact time of the atrocity, and they give them the witnesses they're going to use, he can't give them the witness list of the witnesses he's going to use. And since they're the same witness, they're kind of having a standoff. But it's now been 11 months since the state filed its request for disclosure alibi demand on May 23rd, 2023, and he's right about that. And he goes on to, state case law and everything, but I mean, he shouldn't have to, because he's 1,000% right based on Idaho code. And the only way this is not compliant is if the judge would have ordered throughout this process, and he did not. So the fact that it's been 11 months without an order from the judge is perplexing. Then his last statement was, based on the above, the state respectfully requests the court enter the order denying the defendant any further opportunity to add any purported claim of alibi and preclude testimony by anyone other than the defendant as to the defendant's absence or presence at the scene of the homicide. Now, this is April 26th. My point here is this has been going back and forth now this is 11 months on this one issue, and the judge has never ruled. The prosecution has put a little bit of pressure, but not a lot, and the defense is deflected every time. And what happens? Now the defense knows the prosecution is hiding an additional witness that can be used in the case. If they watch my videos, which they do, they know who that additional witness is at this point. After filing this motion, Thompson realized what the defense was doing with Wawa Park. He knew he would then have to use all of his witnesses in the case, and therefore he filed a sealed motion to limit the testimony of those witnesses. And this has always been something that, we've had a hard time figuring out what the heck that they had filed to elicit that response from Ann Taylor that they got. But this is exactly what happened. After he filed this response, he looked into it closer. He realized that by going to Wawa Park first, he can't be the car circling the house 3 times before 4:04 a.m. So without that car, that took a lot of the evidence that Thompson was going to use against Kohberger. So now at that point, he knows what the defense is up to, and he knows he's going to have to use his witnesses. Those confidential informants are going to have to be corroborating witnesses. That's why you see TF get sentenced on April 17th, because he wanted him to be somewhere where he knew he could get a hold of him quick. So again, after that on 4/26, we don't know when it was filed, but we know that the state files under seal a motion to limit the testimony of witnesses. And the only reason we know that is because Ann Taylor on May the 10th, 2024, filed a response to the prosecution's sealed motion to limit testimony. She filed her response, but she did not file it under seal for a reason. She wanted it out into the public domain to get eyes on what was happening. And here it is. The defendant's response to state's motion to limit testimony. And come now, Bryan Kohberger, by and through his attorney, submits the following response to the state's motion to limit testimony filed May 10th. That's exactly what that was. He filed a motion to limit the testimony of the state's witnesses and Kohberger's witnesses as it relates to Cy. In the state's motion, the state contends that the affidavit of probable cause is irrelevant at this stage. And you can bet he had to put irrelevant at this stage because he knows, I'm sure at this point, Ann Taylor knows who his informant is. He knows that they're going to be able to prove that that's not his car making the first 3 passes, so he states the PCA is irrelevant. The state cites no authority for this claim. Mr. Kohberger has the ability to challenge the probable cause affidavits in this matter that were used to procure warrants, because a main part of that warrant was the movement of the Elantra. And then the reason she does this right out in the open is because she wanted everybody in the public to see the cases she was citing, I assure you. because she cites State versus Thompson, finding informers' reliability a relevant issue as it related to probable cause for a wiretap. She cited State versus Hosey, finding informers' reliability a relevant issue as it related to probable cause for a search. I have gone through those cases for you in past videos, and both of those cases revolve around warrants issued from confidential informants for drug cases. She did this for a reason. And then the last one was finding field performance of a drug dog properly discoverable as relevant to probable cause. So she wanted all that out into the public. The finding of an indictment does not preclude a defendant from seeking to gain through discovery information relevant to the probable cause provided to the court. So they're wanting the discovery at this point of those witnesses. And they want the discovery of the witnesses because, like she cites in there, she's going to get them disqualified due to their informant's reliability. And this is May 10th of 2024. Very contentious back and forth with this. And then if you remember, I'm not going to show the court cases, but in court, everybody was nervous. They canceled 2 court hearings after this motion was filed. And when they did get to court, the judge acted really weird when he was asking Ann Taylor about 8 times, could he seal the state's response to this? And she finally agreed. But here's my point. Even after all of that, John Judge never rules on any of this, and it's not settled to this date. Why wasn't this brought up in the status hearing with Judge Hippler? The prosecution has been fighting to get the alibi now since May of last year. It's almost a year and a half. They've been fighting to get the alibi, yet with no ruling by any judge as required in Idaho criminal rules that we looked at. This shouldn't have went more than 10 days. And nobody is fighting and arguing over this? It doesn't make any sense. When you start going through all of the documentation as it relates to just the alibi, I hope that if you kept an open mind, you paid attention, you can see how the events in all of that corroborates my 5-part series and my thinking. Now, obviously, that's not the only thing that corroborates it, but there was so many things in there that corroborates it even further. And I could probably do 50 videos with completely different things that corroborate the things I said in my 5-part series. But this one should just be another one. And the main point I want to get across is they've been fighting over this alibi now for a year and a half. No judge has ever ruled on it. And it's clear in Idaho code that the only way you can extend it out past 10 days is with a judge's ruling. Now, the prosecution stipulated an extension one time. Other than that, it's never been ruled upon. So I think at this stage of the game, now the defense has all of the discovery evidence that they're supposed to have. Well, we would like to see the alibi. And there's no reason for the state to not be pushing to see that alibi, other than the fact that when they do put the real alibi out, it's going to put so many questions in people's minds about the actual guilt of Bryan Kohberger that they're going to lose the narrative out there in the mainstream media as well as social media. So they're not pushing to get it out for that reason. And the defense doesn't want to put it out for legal reasons because they're defending a case. But at this point, we all deserve to know what the truth is. So where's it at? Put out the alibi statement. Prosecution, demand it. Defense, present it. Let's get it out there now. It's time. But folks, please like and subscribe to the channel. Post your comments, your thoughts, your criticisms. I know I did a lot of talking in that one. You may have to slow it down, rewind it, whatever you need to do. Until next time, Pavarotti's out.